Entering the criminal justice system is a terrifying experience. The immediate consequence is the complete loss of your physical freedom. But Indian law operates on a core constitutional principle under Article 21. That principle dictates that bail is the rule and jail is the exception. To help you navigate this system, this guide will decode the updated Bharatiya Nagarik Suraksha Sanhita, or BNSS. We will walk through the exact difference between regular and anticipatory bail and give you a step-by-step checklist for your application. Protecting your constitutional liberty is possible, but it requires knowing exactly which legal lever to pull and exactly when to pull it. Under BNSS Section 2B, bail is the release of an accused person from custody on specific conditions. Section 2E defines a bond as a personal written promise to appear. Section 2D defines a bail bond, requiring a surety who pledges financial assets. Misusing these terms can delay your release. You must know if the JENT requires just your signature or a financially backed guarantor. This timeline illustrates when to apply for protection. Before an arrest, apply for anticipatory bail under Section 482 to prevent it entirely. If the arrest has already occurred, your only option is regular bail under Section 480 to secure release. When reviewing an anticipatory bail request, the court evaluates if the complaint stems from malicious intent and whether you pose a risk of fleeing the jurisdiction. Timing dictates your entire strategy. Filing for anticipatory protection after the handcuffs are already on is a guaranteed procedural failure. When you file, your formal application must clearly articulate strategic grounds for your release. Ground 1, pointing out weak evidence. Ground 2, citing severe medical conditions. Ground 3, being the sole breadwinner. To support these claims, you must attach specific documentation. The checklist requires a valid government ID, a highly legible copy of the first information report, verified proof of your current address, and a sworn affidavit stating your concrete facts. Once compiled, there is a strict rule. You must serve a copy to the public prosecutor. Missing a single document or failing to notify the prosecutor will instantly stall the application and leave the accused in custody. If the court grants your application, your release comes with strict behavioral conditions. You will likely have to surrender your passport and adhere to a mandatory court attendance schedule. Any attempt to tamper with evidence or make contact with witnesses will trigger an immediate revocation of your bail. Throughout this process, you retain the constitutional right to legal counsel and a prompt hearing, no matter how severe the charges against you are. This text from Section 430 covers post-conviction bail, used when a trial ends in a guilty verdict but the accused intends to appeal. As detailed in the clauses, you qualify if the sentence is under 3 years or the offense was bailable. Remember, bail is never a permanent victory. It is a temporary freedom that demands perfect legal compliance until your final verdict or appeal is entirely resolved. Securing your release requires a precise sequence of actions: identifying whether you need a personal bond or a surety, timing your application for anticipatory or regular bail correctly, and submitting flawless paperwork. While these procedural steps are standardized across the country, the legal strategy for every single case is unique. Navigating this requires the guidance of a qualified criminal defense attorney. Knowing your rights, organizing your evidence, and acting with precise timing is the only way to protect your physical liberty in the Indian justice system.